From the WATE.com Digital Center, answering your legal questions. This is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Hi, everyone. It's a Wednesday afternoon once again, and we're talking about some legal cases that have really shocked our community today. One in particular. Greg, it's always good to see you.
Lori, it's good to be here.
We're going to focus in a second on victim impact statements, and that's always the point in the trial, I think, where a lot of people find that it's the humanity comes into play, where you really see the emotions. It's not really law-driven, it's emotion-driven. But this centers around a 15-year-old's victim impact statement in a case that is just absolutely horrifying when it comes to child abuse and the death of two kids. Let's bring everybody up to date on the Gray case.
You know, Lori, it actually, when you hear about the facts that were articulated in court regarding the Gray case, I mean, it literally, it is so extreme. It seemed like a very poor episode of CSI or something to that effect. But anyhow, these individuals had a number of foster children. They were locked in a basement for a period of years until one 15-year-old boy escaped. His foster sister was also locked in a basement, denied food, water, basic amenities. She was dead. They kept her in a cardboard coffin for a period of time before they buried the body on their property. To punish the children for things such as stealing food, bread, and water, they were locked in animal cages or punishment boxes, and you could tell the visceral reaction from the judge, the prosecutors, individuals in that courtroom as this plea went down in Roane County.
You really could. In fact, let's go ahead, take a look and a listen at the judge in this case.
I'm just appalled with what I've heard here today, and to me it's just pure evil. And please take them into custody.
He says, get him out of here. And this case is not over yet, right? Greg, we have the couple's son and co-defendant here in Knox County, Michael Gray Jr. His case is still pending in Knox County Criminal Court, and I believe he has a status hearing on Friday.
His case is still pending. Their theory is that he was somehow involved in the felony murder and the extreme aggravated child abuse of these children. So that is still pending. But, you know, Lori, one of the things in this case highlights the power of a victim impact statement. And in this case, the 15-year-old, when he was given his right, which it is a right to make a victim impact statement, he addressed his foster mother and father and said that basically your house was my prison. Now prison will be your house.
That is so eloquent.
It's chilling.
It's chilling, and it has such deep roots, and it's so emotionally mature for a child who's been through what that child has gone through. This child left the home wearing a mismatched pair of shoes that he was able to find, his teeth all black, couldn't chew his food. As a mom and a grandmother, it's hard to even talk about.
It's hard to talk about, but that brings us to the heartfelt statement that he made in that packed courtroom.
And here's another one really quickly, and I want to talk more about the law and the victim's statements. He also said, don't do unto others as they have done to you, even though you have done evil. Looking at them, he said, I forgive you. Let's look at the weight that carries.
You know, it really does. And what are victim impact statements? Victim impact statements only occur after someone has been convicted or after they have entered a plea of guilty. In 1994, Tennessee enacted the Victim Impact Statement Act. And what that means is in every criminal case where there's bodily injury, there's death, sexual assault, or serious economic loss, that you have an absolute right as a victim to give a victim impact statement. Also, the Department of Corrections is directed to put a victim impact statement in the pre-sentence report that's considered by the prosecutors, the judge, etc. But what's so important about the victim impact statement, as a matter of law, the judge is to consider that as he's weighing aggravating and mitigating factors in imposing the correct sentence. And I will tell you, until you have sat in a courtroom, and you know, people talk about prosecutors and lawyers and judges, or you know, what a great cross-examination, or what a great objection, or this judge is fiery.
Just the rules of the game, if you will, but this goes so much
This
deeper.
is out of all of our control, because it's the bumpers are off, and you have somebody that typically is hurt, someone that has suffered great loss, and they get to address the court and tell them the sentence they want. But here's how raw and unbridled it is. I mean, I've been in a courtroom, and the victims look at your client, they look at you, and they will tears in their eyes, damning you to hell, talking about how your client or someone has ruined the life by prescribing opioids, talking about how this sexual assault impacted a young person and will impact them the rest of their life. But then again, there are other times when you're sitting there, and you know, you expect to hear, you know, the rawness and the hurt and the emotion, and someone says, "I forgive you. You know, I'm a bigger person. My faith is bigger than this situation." But my point is, the lawyers can't jump up and cross-examine the person. The lawyers can't jump up and object.
This is their right.
This is the right, because remember, it only happens if you've been convicted by a jury or you plead guilty. And you know, Tennessee is a very victim-conscious state. Not only do we have the Victim Impact Statement Act, Article 136 of our Constitution was amended to give victims certain rights. You have the right to be present at all hearings in the criminal process. You have the right to be heard. You have the right to be informed regarding plea negotiations. Now, you don't get an automatic veto. So you can't say, "I approve or disapprove that sentence."
But you also don't have to stand up there and give your impact statement. If you're just not the type to get up and talk about your feelings and you know, have the wherewithal to address the people who've perpetrated the crime against you or your loved one, you don't have to do that.
And Lori, that's an excellent point. Victim impact statements are voluntary, but in every case, the court literally on the record will look and go, "Do you want to make a victim impact statement?" And but like I said, it is a moment in a courtroom where all eyes are on the victim, and it's their time, and it's aside from all the law, all the arguments, all the preparation, that victim's heartfelt statement has to be considered by the judge in making that decision.
We could tell what the judge thought. And again, these two people, the Grays, are going to prison for the rest of their lives. But we also heard from Knox County DA Sharm Allen. She said, "I've seen a lot of these cases." She was affected, just like everybody else who heard this. Let's listen to her real quick.
Yeah, I think we learned a lot. You know, we even learned things I think that we didn't know. The victim impact testimony from both the minor child that testified from a victim in this case, and then the therapist for one of the other kids was impactful. I think you heard from the victim impact statements that neither of the boys wanted the Grays, the bad parents, to be executed or to die. They wanted them to sit in their own prison and have to think about what they did to them and see what they become. So that, you know, that was really the deciding factor in putting all this together.
We always take the wishes of the victim into account, and as you heard, as General Johnson has also stated, that these were victims who preferred that these defendants spend the rest of their life in the penitentiary, to trade a prison for a prison, if you will. So that went into part of our decision as to why not to seek the death penalty. And once we notice with the death penalty in Knox County, we don't remove that.
All right, there you go. There's another aspect of this, the death penalty taken off the table in large part because the kids didn't want it. They wanted them to sit in prison and think about what they've done.
And that's a good example to show how much deference prosecutors give victims in terms of charging decisions. And this was the ultimate decision, whether this was going to be a capital case, a death penalty case, or whether it was going to be, I think the sentences were life without parole and one was life with parole. Tennessee first-degree murder is 60 years. You get 15%, so it works out basically to 51 years that you're incarcerated. But I thought what was telling is when General Johnson, and he said, we learned something for the first time during the victim impact statements. Now that goes to show you how raw and how impactful and how chilling they can be. And in a case like this where the evidence is overwhelming and they're pleading to extreme sentences to save their lives, you don't have the judge, on the bubble deciding whether someone gets probation, not probation, whether they get a few years, a lot of years, whether a sentence is stacked. But, and this is a good example that we talk about our system of justice and you watch things on court TV, but regardless if you're the individual wearing the robe, if you're on the left-hand side of the courtroom, you're a prosecutor, you're on the other side as a defense lawyer, they're all human. And, all the great statements and oratories and quotes and preparation really pale by comparison to a victim impact statement, because that judge has children typically. That judge has a spouse. That judge has elderly grandparents, and when they hear of something that is this heinous, atrocious, and cruel, they get impacted. So and the other thing that I've seen. Often we spend time with witnesses and going over their testimony, preparing them, both the prosecution, both the defense. But victim impact statements is typically you go out there and speak from the heart. So, if you're the defense lawyer, it's one of the most helpless positions to be in a court because your client's already been adjudicated as guilty. And that emotion just flows and really can overwhelm a courtroom.
I want to end this. We'll talk more at 5:30 on some of the facts of this case and kind of the takeaways of this. But I want to leave you all with this because this really touched me, and it's almost hard to say, but it was so good to hear that this 15-year-old said that he's enjoying chocolate, finding out what just the simple pleasures of childhood, searching science projects online, doing things that thankfully a typical 15-year-old would want to do. And to me, I thought, good, I hope he's with somebody who will help him make this transition into a healthier life and a healthier adulthood and some happiness down the road.
You really, one wonders how you can have such a lack of oversight and supervision, and you have people treating children in a way that if this was an animal cruelty case, we would all be up in arms, and we're all up in arms in this one. But you don't contemplate that there are foster parents, other people out here that do this, and it goes to show. Sometimes it's better to pick up the phone if you've got suspicions, and better be safe than sorry, because think about this. This was literally a prison hell on earth where these children were detained, starved, murdered in broad daylight.
Not survive.
In broad daylight in Roane County, Tennessee.
All right. Greg, thank you. This was tough to talk about.
It's very emotional.
All right. Thanks for being with us.